Welcome back, everybody, to the law of contract. In this lesson, we are continuing talking about the terms of a contract, moving away from the terms which are expressly stated in the contract, i.e., conditions, warranties, and innominate terms, and moving on to examining the circumstances in which we might find a contract having terms which are implied into it, implied terms. In these next few lessons, final few lessons on the subject of contractual terms, like I said, we're talking about how terms may not necessarily exist in the contract themselves, but rather be implied into the contract by courts normally. So, implied terms, like it says here, don't actually exist expressly or explicitly in the contract. There isn't a clause 4 that is this term, for example. There is just this idea that a term may be implicit in the nature of the contract itself. And there are sort of two ways in which it can be implied into a contract. Terms can be implied by way of a court. A court may conclude that an implied term exists. There also might be customary reasons why a term is implied, given the facts of the particular contract and the particular market that contract is seeking to regulate. This may also be a way in which contracts may have terms implied into them. This is also something that would also be determined by a court, often when there is a dispute. You could also find ways in which a term can be implied using the Consumer Rights Act from 2015. Now, we're not going to spend too much time talking about the Consumer Rights Act in this series of lessons. We'll do one lesson on it, just covering the basic provisions. But for the most part, the Consumer Rights Act is going to be limited to a series of lessons that we will do in the future on consumer marketing law and commercial law more generally. Again, though, this is something that's going to be in the works in quite a while, so we won't cover it in too much detail here. So, when it comes to the work that a court can do in the area of implying a term, there are two main ways in which a court may be able to introduce implied terms into the equation. They can be implied either in fact or they can be implied in law. And we're going to focus firstly on the first of these, the implication through fact, in this lesson. We're also going to talk about a particular test that is applied in certain circumstances known as the Officious bystander test in the next lesson, and then in the final lessons we will talk about the ways in which terms can be implied in law, and then finally finishing on looking at the other focuses in which terms can be implied, i.e. through the Consumer Rights Act. So terms implied in fact, what does this actually mean? Well, a term will be implied in fact where there are issues which are left out of the contract itself. It is as simple as that. So if there are terms that are left out of the contract itself, but owing to the issues which are omitted from the contract, a court may have to imply that certain terms exist in order for a contract to be operational. So if you have a contract, and within the contract there are various different express terms that say X, Y, and Z, but in order for X, Y, and Z to actually take place, to actually be able to be operated, there has to be another term that exists, but maybe this term isn't actually in the contract itself. Well, the courts would say that given the fact that this term that doesn't exist, that doesn't actually find itself in the contract itself, given the fact that in order for the contract to actually be operational, this term has to be there, then it is implied that that term exists. And it's also implied that the parties to the contract agreed to this term in order for the contract to be operational. It must be shown, therefore, that on a factual basis, terms had to be there in the first place if the contract was going to operate in the way the parties intended it to operate. And this strikes to the heart of the party's intention, because if the parties intended the contract to operate in a specific way, and in order for it to operate in a specific way, it would require the existence of this term that doesn't actually exist in the contract, then it means that, therefore, the parties sort of de facto intended for this term to be in the contract itself, given the fact that they intended it to act in the way that this term requires. A useful illustration of this is the case of the Moorcock from 1889. This case is instrumental in introducing a particular test for a court to imply terms into a contract. This is known as the business efficacy test. Essentially, a court may imply terms in fact on the basis that the existence of those terms are efficacious for business. So, how can we use this case to provide ourselves a useful illustration of this concept? Well, the claimants in this case had been the owners of a ship, and a contract had been in place which stipulated that the ship was going to be unloaded at the jetty by the defendant, the jetty of the defendant at least. While the ship was being unloaded, it was damaged at the jetty of the defendant. The argument by the claimant was that there ought to be a term implied in the contract that stipulated the defendant ought to take reasonable care in ensuring the safety of the ship. So, essentially, the claimant argued that they breached their contractual obligations in terms of taking reasonable care to ensure the safety of the ship. But of course, that is not a term that is explicitly in the contract. So the additional argument, of course, by the claimant was, not only is this a breach of the contract, but it was a breach of an implied term within the contract. That it was implied by everyone involved in the contract that this should be a certain reasonable care taken in ensuring that the safety of the ship was to be protected when the ship was at the jetty of the defendant. It was held by the courts that this term was indeed implied into the contract. It was done on the basis that the term itself would be efficacious for business purposes. It wouldn't make much sense to suggest that a term of this nature doesn't exist in a contract where people are handling where the defendant was handling essentially the property of the claimant, such that them not taking reasonable care would have left damage to the claimant's property. So, Lord Justice Bowen developed the view that where it gives business efficacy, a term may be implied in fact, but that this principle does not just imply terms which may be desirable, which is, in my opinion, somewhat unfortunate, given the name of the test is business efficacy, implies a certain amount of desirability when it's efficacious for something to take place. It implies that it is not something that is necessary, or is something that is really something that is quite a significant requirement, but it does lean more towards the side of desirability. But of course, the title of the test does not necessarily speak to the nature of the test. So given the fact that this was, the defendants in this case had known about the fact that there was a low tide, and since there were the owners of the jetty, and since this was information that was not available to the claimants didn't know about the low tide, the contract must have included the implication that the defendant would have taken reasonable care to protect the ship. Because if not, then on account of the fact that the claimants did not have this information available to them, the defendants could have just acted in any way, and there would have been no recourse or any remedy for the damage that could have been caused to the ship itself. If not, the contract would fundamentally not be workable. It wouldn't be workable to suggest that the defendants would have been able to, the contract would have able to have been taken place, given the fact that it was a contract whereby we are talking about the docking of a ship and unloading at the jetty of the defendant. It wouldn't have been a workable contract if there was no provision at all, which ensures that there is at least a reasonable amount of care that is essentially implied onto the defendant in this case. Welcome back, everybody, to our study in the law of contracts. In this lesson, what I want to do is talk a little bit about the Officious bystander test, which is a test which relates to the implication of terms, i.e. implying terms into contractual arrangements. And this is only going to be a short lesson, given the fact that this is not a particularly complicated or convoluted test. And we'll just recap some of the things that we've been talking about in the previous lessons, and we'll talk about essentially the roadmap for the next few lessons as well at some point in this lesson too. So, the previous lesson introduced the subject of implied terms. We noted about the ways in which a term may be implied by a court. We had noted that when we talk about implying terms, there are three main ways which terms can be implied into a contract when it comes to the sort of practical implication of a term. Firstly, being implied by courts. Secondly, being implied through custom. And then thirdly, being implied through the imposition of the Consumer Rights Act from 2015. And then, when talking about the first of these prongs in relation to the implying of terms, implying terms by court can either be done through fact, implication by fact, or implication through law. So, one of the things that we noted is that implied terms in fact can be established if they would be efficacious for business purposes. We talked about the case of the Moorcock, in which you have the defendants being the owners of a jetty, you being the claimants being the owners of a ship that was unloading at the jetty, and it was argued that there was an implied term that the defendants take reasonable care in ensuring that there would not be damage done to the to the ship itself. And it was seen that this would be efficacious for business purposes rather than just be desirable. It's struck at the heart of the contract itself. This lesson is going to talk about the second process by which a term may be implied in fact, this being the Officious bystander test. So generally speaking, when we think about terms implied by courts in fact, there are two routes in which you can go down. You have the efficacious business test, and then you have the officious bystander test. What the officious bystander test tells us is that we can imply terms which are considered to be so obviously part of the contract that it goes without saying. So it doesn't necessarily relate to the conduct of the potential efficacy of the business practice or the necessity of the business practice in order for a term to be implied into a contract. But it's really something that is just so obvious. It's so obvious that this term has to be part of the contract itself, that the idea of it not being the part of the contract doesn't make any sense whatsoever, and therefore we can imply in fact the existence of this term through courts. It goes without saying that this term is required for a contract. It is called the Officious bystander test because it comes from the case of Sherlaw and Southern Foundries Limited from 1939. Specifically, this quote. They say, quote, "Prima facie, that which in any contract, if left to be implied, is something so obvious that it goes without saying, so that if, while the parties were making their bargain, an officious bystander were to suggest some express provision for it in their agreement, they would testily suppress him with the comment, 'Oh, of course.'" So essentially, what this test requires us to do is to imagine, let's say, that we are at a cafe and that I am a random bystander that's listening in on the negotiations of a contract between two people. And I go up to them and say, "Oh, by the way, this term should be in that contract." And that they respond with, "Oh, of course it should be. Of course it should be." That is essentially the officious bystander test, such that any bystander any reasonable bystander that would just be able to happen upon your conversation with another person negotiating a contract would know immediately, upon knowing the express terms in the contract, they would know immediately which other terms should be part of the contract, and that when those terms are cited by this officious bystander, the people negotiating the contract would have said, "Oh, of course, what a silly idea," and to not have this in the contract. So that's what the officious bystander test means. That's where the phrase comes from, and that's where the word comes from. Essentially, what you do is you associate yourself with a negotiating partner at a table in a restaurant. You are assuming that you are negotiating a contract, and the negotiations are overheard by an officious bystander. And if the said bystander were to ask if the contract was going to have X term in it, and you both respond in the affirmative, then this term will be implied in fact by the courts. That's essentially what the officious bystander test tells us. And what it means, therefore, is that these are terms that are so obvious that they have to be a part of the contract, that they are almost de facto and prima facie in the contract, just through the nature of the contract itself, through the nature of the contract and the facts of the terms of the contract that are expressly cited. And so as a result of that, that's why we determine that this is a way in which the courts can imply a contract imply a term in fact. If you look at the facts of a contract, you look at what the contract says, and you go, well, this term has to be in it, because if it doesn't, then it doesn't make sense, then this is an implied term through the officious bystander test. Previous lessons have spent a little bit of time talking about the ways in which terms can be implied into a contract. We noted, for example, that terms may be implied into a contract in fact, and we noted that there are two major tests that we can look at to make a determination as to whether or not a particular term may be implied by fact. This lesson is going to talk about the ways in which terms may be implied through law. And what I'm going to do is essentially just do a basic overview of what we've been talking about so far in the previous lessons, and then talk about how we make the shift from terms that have been implied in fact to terms that are implied through law. The last two lessons looked at the two main tests for determining whether or not a contract may be implied in fact. A contractual term may be implied in fact. We noted that these are the business efficacy tests versus the officious bystander test. The business efficacy test refers to this idea of a term being efficacious for the business practice, such that it is almost necessary for that term to be existing in that contract. If that is the case, whereas it is not actually expressly stated in the contract, it will be implied into the contract. The officious bystander test is actually one of my favorites, because essentially what the officious bystander test tells us is, assuming that somebody is overhearing your conversation where you are negotiating a contract with another individual, and they come up to you and say, is this term in the contract? And your response is, of course, yes it is, then this implies that that term should exist in the contract, given the fact that it is so obvious that just an overhearing officious bystander may be able to implicate that term in the contract, and so as a result of which it is so obvious that it should therefore be in the contract. So, like I said, previous lessons are talking about the implication of terms by fact, representing situations where it is clear that the parties in the contract, the parties in question to the contract, had implied these terms without expressly stating it or necessarily having them expressed in the contract itself. When it comes to terms which are implied by law, it is often irrelevant whether the parties had in fact originally intended for them to be included in the contract or not. In fact, terms which are implied in law are actually very, very different to those that are implied by fact. The fact of a particular circumstance may give rise to the existence of a contractual term that has been implied, owing to the fact that it is necessary for that term to exist. And it is also necessary on the part of is clearly an intention on the part of the parties for that term to exist in the contract. But when we think about terms that are implied by law, it is often irrelevant, as I've said here, that whether or not the parties had originally intended for them to be included or not. They're often implied into contracts for the purposes of protecting the interests of parties to the contracts. So where it is clear that a term needs to exist for the protected parties to actually have their interests upheld and their interests protected in the contract itself, then it may be implied through law. An illustration of this can be seen in the case of Liverpool City Council versus Irwin from 1976. In this case, we see that terms may be implied into contracts in order to protect the weaker parties to the contracts. So this doesn't necessarily speak to the facts of a particular case, or even necessarily to the intentions of the parties, but it may speak to the views and the relative power dynamics that exist within a contractual arrangement, such that the weaker parties need to have some kind of protection, and so it is implied in law that those terms exist. The case itself involved a council that ran a number of tower blocks, which had alleged to have been deteriorating. And it was argued by the Liverpool City Council that, or at least it was argued that the Liverpool City Council had in fact breached their contractual obligations owing to the implied term that the flats had such repairs were necessary for the enjoyment of that property. So by reference to the fact that they had owned and ran this tower block, the Liverpool City Council were therefore in breach of their obligations for the fact that they had a duty implied into the contracts to make necessary repairs for the enjoyment of the property. At the level of the Court of Appeal, what was introduced was something of a reasonableness test, a reasonable standard, which is of course an objective standard test, for suggesting how terms may be implied through law into a contract. And they suggested that the terms may be implied on the basis of this test. This was something which was ultimately rejected by the House of Lords, however. The terms were not implied in fact, but rather they were implied in law. It was implied not on the basis of the facts and the factual implications of the particular circumstances, and a fact-based implications test therefore was not necessary for the implication of a term in this contract. In the same way that we looked at previously, it wasn't necessarily efficacious for business, or it didn't necessarily fit the officious bystander test. Rather, the terms were implied in law on the basis that it would be desirable for an obligation to be placed on the owner of such a property to ensure that the property itself maintained the basic standards of living. And so as a result of which, it was irrelevant as to the intention of the parties, whether or not they intended for this contractual term to exist in the contract itself, or any other kind of test that may be introduced on the basis of facts, like a reasonable person test, a reasonable person or a reasonableness test for the enjoyment of the property. Instead, it was an obligation in law on the basis of the fact that there should be this obligation for the owners of such property to ensure that the maintenance of this property were up to the scratch of the basic minimum standards of living. In continuing our discussion on the subject of contractual terms, what we're going to do in this lesson is talk a little bit about the 2015 Consumer Rights Act. Now, this is going to essentially involve us reading quite a few provisions from the Consumer Rights Act, and this is obviously partially because the Consumer Rights Act is relatively well made and well written, such that it requires us to basically just be able to list off the provisions, and this gives us an indication of how contract terms may be implied into a particular contract on the basis of the fact that it is protecting the rights of a consumer. This is one of the most important ways in which terms of a contract or terms to a contract can be implied into an agreement that is under the auspices of the Consumer Rights Act itself. Of course, we're not going to spend huge amounts of time in this series of lessons on the law of contracts talking about the Consumer Rights Act in a great amount of detail. Theoretically, we could do. However, it is more important, at least in my opinion, to be moving on and talking about the elements of contract law that concern itself specifically with contracts, not necessarily with consumer rights and marketing law or commercial law, all of which are going to be subjects that I'm sure we will get into in future lessons' time, in future series. So that's like what I've said here. In this, we will potentially do a module on consumer rights law in the future, but for now, we're going to just spend a little bit of time talking about the way in which terms may be implied into contracts under the 2015 Consumer Rights Act. So one of the provisions within the Consumer Rights Act provides that goods which are sold, bought and sold by consumers, and obviously sold by producers, ought to be of good, satisfactory quality. This is outlined in Section 9. Now, Section 9 says the following. It says that every contract to supply goods is to be treated as including a term that the quality of the goods is satisfactory. The quality of goods is satisfactory if they meet the standard that a reasonable person would consider satisfactory. So, firstly, Section 9 subsection 1 makes it clear that every single contract to supply goods is to be treated as including a term that the quality of the goods is satisfactory. This is a term that is implied into the contract, hence the phrase is to be treated as including. What we mean here, therefore, is that if there is a contract to supply goods that does not include explicitly a term relating to the quality of the goods being satisfactory, it is irrelevant that that isn't present in the contract, because any and every contract that supplies goods will be treated as including this term as per Section 9 of the Consumer Rights Act. So the implied nature of the term comes from subsection 1 of section 9, and then subsection 2 of section 9 gives us the definition of what we mean by satisfactory. It is an objective standard, as we can see here, that a reasonable person would consider satisfactory. But it also allows us to take into account a number of factors which can come to and allow for a consumer to come to a better conclusion, or a reasonable person to come to a better conclusion as to how we determine satisfactory quality. So, this includes the description of the goods, this includes the price or other consideration of the goods, it includes all other relevant circumstances. The quality of the goods includes their state and condition, and the following aspects, among others, are, in appropriate cases, aspects of the quality of goods. Fitness, for all the purposes for which the goods of that kind are usually supplied, so comparing that good to any other good of that nature that is usually supplied to consumers. The appearance and the finish of the goods, depending on the type of goods that we are talking about. Of course, the appearance and finish will give quite a lot of an indication of as to the satisfactory quality of that particular product. Freedom from minor defects, safety, durability, all of which are considerations that are necessary for understanding whether or not goods are satisfactory as per Section 9. So, Section 9, subsection 4 says that, quote, the term mentioned in subsection 1 does not cover anything which makes the quality of the goods unsatisfactory, which is specifically drawn to the consumer's attention before the contract is made, where the consumer examines the goods before the contract is made, which that examination ought to reveal, or in the case of a contract to supply goods by sample, which would have been apparent on a reasonable examination of that sample, of the sample in question. So this is providing something of a limitation to what Section 9, subsection 1 actually implies into a contract supplying goods. It is something of a removal of suggesting that it implies any term for the quality of the goods being satisfactory. It does not cover anything which makes the quality of the goods unsatisfactory. So that's one of the main areas in which the Consumer Rights Act from 2015 is able to imply into a contract terms relating to the quality of goods. Now, we will get to remedies in future lessons' time in more detail when we talk about the remedies generally to contracts. But for now, let's have a look at some of the remedies which are proposed within the Consumer Rights Act of 2015 for violations specifically of these kinds of provisions. So, for example, Section 19 says that, quote, if the goods do not conform to the contract because of a breach of any of the terms described in Sections 9, 10, 11, 13, and 14, or if they do not conform to the contract under Section 16, the consumer's rights are short-term right to reject. This is found in Sections 20 to Sections 22 of the Consumer Rights Act. The right to repair or replace, which is found in Section 23, and the right to a price reduction, or the final right to reject, as is in Section 20 and then in Sections 24, all of which gives an indication of the processes for remedies by which you can actually essentially reject the goods in question because they do not perform and do not conform to the basic satisfactory qualities and standards that are required as per sections 9, 10, 11, 13 and 14, or you can have a right to price reduction, right to repair or replacement. So fundamentally, these are instances in which we can imply terms into a contract for the purposes of consumer protection and to protect consumer rights. We're planning on attacking this subject in far more detail when we do a series on consumer rights law. So if you feel like at the time being, at the time of recording at least, that this isn't enough detail, then please come back when we do consumer rights law and we start to unpack this in far more detail. For those of you who are watching this video in the future, in maybe 3 or 4 or 5 years' time, and we already have a series on consumer rights law, then feel free to go over to that playlist when it is made for more detail on this particular topic.